69 degrees and 32 below on the farm, so it's not hard to figure out. We made a decision to move. My wife's youngest in the family, so we stayed with her parents until they were no longer living, and then we moved out with their wife.
So you reduced miles from the Canadian border.
9 miles.
9 miles. Is that Montana or what was the state you're in?
North Dakota, Montana is to the west.
Yeah,
and
North Dakota.
I lived on the Canadian border when I was a kid.
okay, where and what?
Michigan, Sault
in
Ste.
Michigan,
Marie.
okay.
Sault Ste. Marie.
All right. More snow for you. Ours is just bloody cold. We don't have any lake effect snow like you do in Michigan. So anyway, I'm sorry.
He's a Canadian.
Oh, yes, I knew that Glenn was.
He walked to.
Where are you from, Glenn?
Canadian.
Sorry?
What province are you from? Are you from Toronto?
Well, you've heard of the Alberta Clippers, haven't you?
Yeah. Are they out of Edmonton or Calgary?
Well, I was, the hearsay is that I was born in Peace River, which
I've
is,
heard of it.
which is
Place to fish.
about 400, yeah, it's a big, huge river for sure.
Yeah.
It's about 400 miles, 600 miles, about 400 miles north of Edmonton. And it's on the, well, it's about 600 miles south of the, is it the Arctic Circle?
Yeah. That would be
I remember walking to school when it was 69 below.
Did y'all hear that? Is that
People don't believe that, but I remember that.
Yeah, uphill both ways too.
Yeah, well, that is.
There you go. I got a comment like
If
that.
that happens in the mountains, see, if the school's in the valley, you can go up in both ways. Doesn't matter.
So yeah,
I've been in 54 below ambient temperature.
Yeah.
That's cold enough.
I was from Sault Ste. Marie, Michigan, and we had not that like that, but they didn't do it all the time. But we had some really. We didn't have air conditioning in the house. My car didn't. My dad's car
We
didn't.
didn't either.
We didn't.
But you didn't get 69 below, no. You didn't get that.
No. But we didn't have air conditioning. It's what I'm saying.
No, we didn't either.
There was no air conditioning in it.
I put an automatic transmission in my truck when we moved here because it stops too much. Our nearest neighbor was a mile. Anyway, my wife's retired paralegal. I was in the energy business for a number of years, also farmed and built homes, and had a construction business for commercial construction as well as oil field construction. So I'm semi-retired.
Great.
I only work 8 hours.
Glad you to be here. Thanks for coming.
Appreciate it. All right. I think we're going to ask Daniel to give our opening prayer. Would you like to do that, Daniel?
Oh, sure.
All right, good morning, everyone. Welcome to the meeting. Father, we just come before you this morning, and we ask you, Lord, to bless each person here today, and even those that are not in attendance, that, Lord, we ask you to bless them. Father, we want to have you open our ears, open our understanding, that we might receive what the presenters have for us today, and that we understand and are able to push forward in becoming free men and free women. Lord, we just thank you and give you all the praise, all the glory. In Jesus' name, amen.
Man.
let it be done.
Yes, sir.
Well, we have a little bit of change in our schedule. Bobby Gray will be here next week for the Texas coin. So it'll be next week. I didn't know till 5 o'clock this morning he couldn't make it. So that's going to be good next week. Steve, you want to go ahead and tell us something you want to come up here or talk?
Yeah, and
Thank you.
last week, riding down the road, bypassing the Goodwill that I go to sometimes, they got a good shirt on. And my intuition was telling me, go inside there, go in. Maybe there's a good shirt for me to get. I was walking by the kitchenware shelf, and I saw this silverware, and it says $4.49 the price. So I went in and bought it. And on the way up here today, I took it by a silver shop. They offered me $350 sell it for you, so.
That's good.
Something else. And, there's 5 pieces of each, except for this little fork. There was 10 of them, so I gave them 5 of the little forks. They gave me $70 cash. So, but I got these because you're supposed to eat off the silver. That's healthy for you. So we're taking it also when silver does skyrocket in value, then this will be worth a lot more. I just wanted to share that with y'all.
That's good.
Good story.
Oh, yeah. So thanks, Dave.
And Park, they gave me cash. And $10. They gave me these $10 coins. I mean $1 coins. They gave me 10 of these.
Good deal. Hey,
What I do also is when I'm at flea markets, I'll walk around looking for silver and gold. And some people don't realize the value of their silver. They just don't understand. But you gotta make sure it has genuine silver on it. There's a lot of fake stuff out there.
Now, at first, you didn't want to buy it because it didn't say silver. You took it back to Boston. It said 80. That means 80% silver.
That's still a good deal.
Yeah.
That's real good.
It said, supposed to say sterling, but it didn't say sterling.
Right. Okay, Glenn, did you get through chewing that up? We can get started?
I'm ready to start whenever
Okay.
you are.
Let's give a good warm welcome to Glenn.
Okay, so today we're going to talk about demurrers. It's one of those words in the law that they never tell you about. I remember reading through these old law books, when I was first learning about this stuff, probably in the 90s, and I was seeing about these demurrers. And I told someone recently that they were in these old common law books on common law procedure, and I checked one today, and it wasn't there. But it was in these old law books. Matter of fact, I found a definition for it in Tomlin's Law Dictionary, 1835 edition. So see me doing it here while we're sitting here waiting to get started. So I'm not done with it, but you can definitely use this anywhere in the USA. This one here is directed at a court in Idaho. You can definitely do this. And what happens when you do a demurrer is you admit the facts, don't dispute the facts, but you're questioning the law, okay? And what happens is the court case stops right there until they prove the law as far as what you're bringing up, the issues you're bringing up about the law. And and when you see this demurrer, you're going to see that it creates problems for them that they're not going to want to even try and resolve, and the case will disappear. And so anybody that's dealing with traffic issues, this is a perfect document for those. Anyways, so we'll get started here. There's gonna be a little PowerPoint presentation that I'm gonna go through, and then I've got the Word files. I want to go through those too. There's a demurrer itself that's about 12 pages. It's not very long. And then there's a motion for discovery, and then there's a motion to dismiss. And that's it. 3 documents. The motion for discovery, I think, is like 4 pages. And the motion to dismiss is 2 pages, or is the other way around. Maybe the motion to dismiss is 4 pages, the discovery is 2 pages. Anyways, it's very, again, with the law, you want it short and sweet. You don't want to put too much stuff in there. There's no reason to go into a lot of details. You just tell them the way it is. And with a demurrer, they have to respond. When we go file these challenges in jurisdiction, they ignore that stuff all day long. You have to take an order in there and get them to sign it. Or the challenge to standing, they ignore that stuff all day long. The demurrer brings up those issues that are in those documents. But they cannot proceed. The case stops right there until that demurrer is overcome. The word is overcome. They have to overcome that demurrer. And when you bring up the right issues, they're screwed. Anyways, so let's get going here. This is a live stream, by the way. It's being live streamed on YouTube. Matter of fact, let's look on YouTube and see what's happening with it. Looks like I got 25 viewers. Okay, so I need to adjust how this is being viewed a little bit. There we go. So people on YouTube are able to see the slides properly. Okay. So anyways, there's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people do not know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? And I see this all the time. People don't even assert their rights that are guaranteed under the Constitution. And you know, simple rights like trial by jury. Never forget the men who started this country were marijuana growing, whiskey drinking, tax evading rebels who left their beds at night to shoot at the cops. Think about it. It's exactly what went on with the War of Independence and the militias, the men who left their beds at night to shoot at the cops. You think about it, the War of Independence was started by them. They were going out and hunting down the military police of the day and dispatching them. Think about it. All tyranny needs to gain a foothold is for people of good conscience to remain silent. I don't trust the government. I don't trust the medical, pharmaceutical, industrial complex. I don't trust the military industrial complex. I don't trust the mainstream media. I don't trust the bankster criminal cabal that owns the government, owns the medical, pharmaceutical, industrial complex, owns the military industrial complex, and owns the mainstream media. And if you call me a conspiracy theorist, I don't trust you. Government's not reason, it's not eloquence, it is force. Like fire, it's a dangerous servant and a fearful master. So a demurrer, this is taken from Black's Law Dictionary, 8th edition. To object to the legal sufficiency of a claim alleged in a pleading without admitting or denying the truth of the facts stated. So you're not, this has nothing to do with facts, you're bringing up the law. To object to the legal sufficiency of a claim alleged in a pleading while admitting the truth of the facts. It's the facts are immaterial. So check out my other videos, Bankster Thieves playlist, Roman cult playlist, bankrupt corporate so-called governments, bar members 1 through 8, do-it-yourself how not to volunteer for the selective service in the draft. You know they're going to be starting up some killing fields here pretty soon, so anybody that volunteers for that is, you know, I kind of feel for them and their family. Martial laws here, do-it-yourself no income tax, do-it-yourself free mail 1 and 2. Do-it-yourself kangaroo courts. Actually, that's on, this is 31 we're doing right now. Canada Border Pigs playlist. Bar members and their satanic connections playlist. So here's another definition of demurrer that was also in Black's Law Dictionary. A pleading stating that all of the facts alleged in a complaint may be true. They're not admitting them or anything, but if the facts aren't brought up, the demurrer is always about the law. They're insufficient for the plaintiff to state a claim for relief and for the defendant to frame an answer. In most jurisdictions, such a pleading is now termed a motion to dismiss, but the demurrer is still used in a few states, including California, Nebraska, and Pennsylvania. I would go ahead and use it because they all recognize common law, and I would go ahead and use it in any state and let them tell you can't use it. See what they do. The word demurrer derived from the Latin demurreri, or the French demurrer, meaning to wait or stay. Imports that the party demurring waits or stays in his proceedings in the action until the judgment of the court is given, whether he's bound to answer or to answer so insufficient a pleading. Okay, so they're talking about the pleading failing to state facts. Remember in the Federal Rules of Civil Procedure, it says, was it 12b6, failure to state a claim upon which relief can be granted. Okay, same idea. The demurrer was general when it was to matters of substance. It was special when it was made to matter of form. It must specifically point out the defect. And this is Edwin E. Bryan, The Law of Pleading Under Codes of Civil Procedure, Black's Law Dictionary, 8th edition, page 1310. This is Tomlin's Law Dictionary. Demurrer, a pause or stop put to any action upon a point of difficulty which must be determined by the court before the further proceeding can be had therein. For in any action, the point of controversy consists either in fact or in law. If in fact, that is tried by the jury, but if in law, that is determined by the court. A demurrer, therefore, is an issue upon matter of law. It confesses the facts to be true, as stated by the opposite party, but denies that by the law arising upon those facts, any injury is done to the plaintiff, or that the defendant has made out a lawful excuse according to the party which first demurs, that is, rests or abide in law upon the point in question, as if the matter of the declaration be insufficient in law. So they're talking about defects in the complaint. So that's Tomlin's Law Dictionary, 1835 edition. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page was deleted, or I deleted it due to censorship on the part of Facebook. My private group called Sovereignty International is being deleted. I've also got a private group at freelist.org called Administrating Your Public Servants. My Google private group is called Administrating Your Public Servants. Follow me on Steemit, Sovereignty International, HowTube, Sovereignty International, and Rumble. Although Rumble, I have a lot of trouble uploading videos there. Sometimes the live stream works, but I really haven't put much there lately. A non-suit. This was also in Black's Law Dictionary. A non-suit is equivalent to a demurrer to the evidence in that even if all the facts the plaintiff presents are true, the evidence is not, as a matter of law, sufficient to entitle a plaintiff to a judgment. However, a voluntary non-suit, unlike the demurrer, is a directed verdict, which you can do in some courts I've seen it where you do a notice of discontinuance. Yeah, I've done a notice of discontinuance in a lawsuit that I filed. I just filed a notice of discontinuance, and that's American jurisprudence. The statement of the plaintiff's cause of action in equity is called the bill. Okay, so the demurrer is not a plea. You have to understand this. Okay, it's not a plea. The statement in the plaintiff's cause of action in equity is called a bill. Okay, everything's a bill. Okay, anything you file is a bill, if you understand that. To this bill, the defendant, unless he can protect himself by a demurrer or a plea, was obliged to put an answer under oath. And so, again, it's a demurrer or a plea or an answer. And that's courts of chancery. Okay, all these courts of chancery are equity. That's what a court of chancery is a court of equity. Some states, they even call it a court of chancery, but most of them have gotten away from that because the judges wear a bunch of different hats, and they want to make it as confusing as possible so they can sell you into slavery. Don't get me going. You're going to get me going. I have exclusive content available on howto.com. It's $9.99 a month for the videos plus unlimited email consultations, but I'm not a liar. Well, I'm in an attorney. No, I'm in a liar. But I can tell you what I would do and where to find the forums under certain circumstances. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I need other people being on point. So some of my exclusive content is in Arlington private information share, land deed training, estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, notice toll roads, notice and demand training. You know I get free toll roads around here, eh? Invoice training, notice of void judgment training, revocation of signature training, third-party witness training, federal habeas corpus training, revocation of voter registration, criminal complaint training. I've actually got about 3 videos up there. I need to do some more. Lawsuit training, I've got 1 video, and there needs to be some more. Other training requests, I'm open to requests, but it's got to be something I haven't already done, and it's something I can do. And I don't do commerce. Okay, that's one thing that a uniform commercial code, I don't go there. That's the law of thieves. You know, anyways, I've got also Northeast private information share videos. I have to do a petition for writ of mandamus video. I think I might do one on this Demurrer because this one looks like it's pretty promising. The videos taken down by YouTube are going to be on my exclusive channel I have got some YouTube videos exclusive, and you can actually go to my website and subscribe to those. But there's not near as many there as there are on HowTube, because HowTube, they don't harass me about what's in my video. So all the ones that YouTube takes down, I put them up on HowTube. And so HowTube has a lot more videos there, a lot more. And then first views on all new uploads, all forms, files, and other instructions are available for free, linked on my videos or on my website. So if you go into the show notes, if the video's like on the Form 1020, and then you go into the show notes on YouTube, there'll probably be a link there to the Form 1020, and you can download it. And don't ever send me a request to manipulate the file, because I don't give it out. You have to download the file onto your hard drive, and then you can manipulate it. People aren't going to be messing with my files. And so you have to download the file, and then you can manipulate it. It's a Word file. Anyways, all exclusive content will be available on howto.com, and you can buy a subscription there. I have no control over any of that subscription process on how you pay for them or anything. You have to do it however HowTube wants you to pay for it. And so that's all done through HowTube. I cannot add you. You send me $10 and I cannot add you to HowTube. I can't do that. And so, I'll have to send you the $10 back. So you have to go to HowTube. HowTube has to take care of it. So remember, we talked about defects. And one of the defects is these statutes are all void for vagueness, okay? And one of the reasons they're void is right here, okay? Because remember, it says Texas Penal Code. Texas Penal Code. And all of these statutes, even the U.S. codes are penal in nature. They're all penal. And once you understand that, if you nail the judge down and get him to admit it to you, he'll tell you that this is a quasi-criminal action. So
But it's not. It's actually a civil action, right?
well, let me get there. I'll get there. Anyways, it's quasi-criminal. That's why it's quasi-criminal. And I've heard of people that have actually gone in there, and when the judge asks them to plea, what they'll say is non-assumption. Okay? They'll say non-assumption. And the reason is that's where the quasi-contract comes from. And so and the judge, I've heard of people, I've seen them, like not seen them, but I've heard of them where the case gets dropped when they say non-assumptive, because you're telling the judge nobody else in there knows what you're talking about, because most people are idiots about that. But what you're telling the judge is, I know you're a little game here, and I don't want to play, and they'll drop it. See what I'm saying? Anyway, so a penal action is an action on a penal statute, an actual recovery of penalty given by statute. Where an action is founded entirely upon a statute, the only object of it is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The ninth penalty is defined forfeiture to be forfeited for non-compliance with an agreement. It's a civil matter. Exactly, Jason. The words forfeit and penalty are substantially synonymous. Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. And where's the disclosure that this is involving a contract and this only applies to U.S. citizens? You know, there's not a shred of disclosure of that. And so, again, they're nothing but a bunch of thieves and pirates. So both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They are contractual in law, but not in fact, being the subject matter of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. And then a quasi-contractual action presupposes acceptance and retention of a benefit by one party with full appreciation of the facts under circumstances making it inequitable him. Remember, these are all courts of equity, making it inequitable for him to retain the benefit without payment of its reasonable value. I've also heard of people go in and say, I waived the benefit, and the case will disappear. Anyways, quasi-constructive quasi-contracts are based solely upon the legal fiction of law. Okay, that means the minor estate. And this is Title 31, Code of Federal Regulations. Entity means the owner of a Treasury direct account, which is not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company trust. The estate of a decedent or the estate of a living person, such as an incompetent or a minor. And then it goes on, a minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years, but has not yet taken control of the securities contained in his or her minor account. So think about it. When you're born, there are securities that are created by the hospital. Okay, you get born in these commercial hospitaliers. Okay, these are Satanists. They create some securities, and they deposit them into a Treasury direct account. And those securities are collecting interest and doing who knows what. They say that there's like billions of dollars in there. I have no idea. Anyways,
That's the original CUSIP.
Whatever. At any rate, so what happens is that if you don't take control of that account, well, first of all, if you do, you fall under their regulations, which means you're still a U.S. citizen. And if you don't, then they call you a minor estate, which is color of law by definition. Anything in the regulations is color of law. It's not real law. It's color of law. Anything in the regulations. And so then they're violating your rights under the color of law, and they do that on a routine basis. And so if you're an entity, this is Natural Mutual Insurance Company, the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. And I'll start down here. It says, in other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia. That's what a U.S. citizen is. And through their plenary power, that's dictatorship, folks, nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. That is dictatorship. That's the Commerce Clause they're talking about. Article 1, Section 8, Clause 3. So the bottom line is they're not telling you any of that stuff, okay? And so this statutory provision merely codifies the well-established principle that the courts acquire authority to adjudicate a matter when they have both subject matter and in personam jurisdiction. They got to have subject matter and in personam jurisdiction. Without a formal and sufficient indictment or information, the court does not acquire subject matter jurisdiction, and thus an accused may not be punished for a crime. So copies of these documents can be found on my website and linked under my recent YouTube videos. For a complete set of YouTube videos with private information shares, a DVD with over 100 searchable law dictionaries and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold to silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the Federal Reserve notes, the forced loans, the military scrip, the securities, the cash app gifts, the checks, the money orders, etc. Send me an email for particulars. If the record does not show upon its face the facts necessary to give the court jurisdiction, they will be presumed not to have existed. So my new book is available, Trump, a True American Patriot or Not. Mike Blackwell asked me to write the book, and he went and hired a company to help us get it published. And they wrote this stuff on the back of the book. And so neither me nor Mike wrote this, but I think it nails it really well. It says, in Trump, a True American Patriot or Not, Glenn Byrne and Mike Blackwell reveal the depths of corruption and manipulation infesting our political system for hundreds of years, regardless of political affiliation. Read the hard evidence that exposes how our elected officials sold Americans into slavery. Understand the Founding Fathers' true intent when they formed a Republican form of government. Discover the influence of the satanic Roman cult on our politicians and political system. Does Donald Trump want to transfer power back to we the people? In Trump, you'll see the great battle that is upon us. So you can order the book from Amazon or from my website. It's $40 plus shipping. It's going to go up to $45 here pretty soon. I prefer you order it by website. Amazon does not provide autographed books, so if you want it autographed, you got to order it from my website.
Did you bring any?
I did. I got some in my car. I'll bring them in. Do you want to know the origins of the deep state and who's behind it? It's in the book. Do you want to know why it's called the Trump administration? It's in the book. Do you want to know what an administration is? You want to know how Trump came to be president? You know, he was invited, right? There's a video with Jerome Corsi. I don't know how many of you have known or heard about Jerome Corsi. He's a guy who's got a PhD in political science, lives up in the Northeast. He got a PhD from Harvard. Anyways, he's written a bunch of books. He's got a website. He's got a YouTube channel. There's a YouTube video where he says that in 2015, 5 generals came to see him, and they said they were going to overthrow Obama. And he said, well, you can do that if you want, but you might want to go talk to Donald Trump first. 3 months later, he gets a phone call. They decided not to overthrow Obama because Donald Trump had agreed for him for president. So my opinion, okay, this book has some of my opinion, very little, but it's 99% provable facts because I use court cases, law dictionary definitions, international treaties, to prove everything I say. Anyways, my opinion is that the entire Trump administration was a giant military psyop, and I think it continues to this day. I think it's all this stuff is for consumption. They need to wake up a sleeping and apathetic people. I heard that Trump was given the opportunity to sign the Insurrection Act, and he actually was considering it. And Sidney Powell was his attorney in the White House chief counsel, and she went home at night and was expected to come back the next day to prepare paperwork for the Insurrection Act for Trump to sign. And overnight, he met with some generals. Might have been the same generals, you never know, eh? Anyways, he met with some generals. They said that he met with generals very often in the middle of the night. It wasn't unusual for him to be. He worked really long hours. He doesn't drink. He doesn't smoke. He doesn't do any of that stuff. So he lives a pretty clean life, and so he's more healthy. Anyways, in the morning, the generals told him, they said he certainly could sign the Insurrection Act, but that if he did, when Lincoln signed the Insurrection Act, within 6 months we were in a civil war, and they expected the same thing would happen if Trump signed it, and that they had gained out all sorts of civil war scenarios, and the Republic does not survive. And so, but they left it up to him. In the morning, Sidney Powell came back, and Mark Meadows, who was the chief of staff, had revoked her White House pass. And so everybody, I remember on the news, everybody was calling Mark Meadows a traitor and all this other stuff. And so then what happened is, and this is all stuff I remember, is that, well, there was a couple things I heard about too, okay? I heard that the Homeland Security that was supposed to give him that report on foreign interference on the election, they refused to give it to him. And so there's a lot of people in the government that are just complete insurrection inside the government. Again, Insurrection Act. Anyways, he, what I saw happen is, you know, the current administration went into office and Trump left. And what happened is about 18 months before his first indictment, he had to wake up a bunch of normies, okay, all these people that are asleep at the wheel. And so about 18 months before his first indictment, I got an email, and it said Trump's going to get indicted, but don't worry, it's all part of the show. And so then Trump got indicted, and just before his first indictment, he came out with a meme, and I still have it. I put it in some of my videos, but I didn't put it in this one. It says, "I am your retribution. If you've been wronged by the deep state, I'm going to go after him when I get to the White House." He's jerking their chain. Think about it. Anyways, so, and then he got indicted, and they indicted him like how many times with these fraudulent, fictitious charges and baseless charges and all sorts of crap. Anyways, and just before his most recent indictment, he started talking about public hangings. Again, he's jerking their chain. And so I think that's why I say it's all part of the show. And he's jerking their chain. And so now they've tried to kill him. I've heard that there's going to be a couple more assassination attempts, maybe one involving an airplane. We'll see, you know. It's all part of the show. And some people swear up and down that that assassination attempt was staged. I don't know. I have no idea. Maybe it was. Who knows? But so the point is, though, is I still believe the military psyop is still going on. Anyways, all of that stuff is not in my book, by the way. That my book was published in August of 2019. Okay, so anything after that is not in the book. Mike has actually been after me to write do a revision to it, and I've been thinking about it. But so we'll see. So you want to know who owns Congress? Why do you think Pelosi would get up there and say, "We can't read this bill until after we pass it"? That's because the owners are giving her instructions, and she's a good order follower. You know what I mean? Anyways, why do you think they're called law enforcement officers? If you look in the Law of War manual, and I got it out in my car, I'll bring it in when I bring my other stuff in. It talks about law enforcement officers. They're military. Anyways, do you want to know how you have become a slave? You know, if you're paying taxes, okay, you're being forced to work for the government for nothing. Think about it. And so, unless you're in some contract, that's slavery. Matter of fact, I took the IRS to the Supreme Court, and that's what I said. This is involuntary servitude. This is slavery. You're forcing me to work for you for nothing. Anyways, and they don't want to talk to me now. Do you want to know what the root cause of the War of Independence was? It's the same stuff that's going on right now. Exactly the same stuff. The courts, everything. It's all the same stuff. Do You want to know why every president goes to visit the Pope on their first international trip? Have you noticed that? Have you noticed that before? They do. It's in the book. So, anyways, I already told you about Mike Blackwell and Jerome Corsi and the 95% provable facts, some opinion. Howard Hughes, you remember Howard Hughes, how he was hiding out all the time?
Yeah.
This is something that actually David Wilcock talked about in one of his videos. And he said that when Howard Hughes, what were the circumstances? I can't remember the circumstances that surrounded it. Oh, I remember. Howard Hughes was a big defense contractor during World War II, right? He got all these contracts. He built spruce goose. He was doing all sorts of stuff. And all of a sudden, he was blackballed. He couldn't get any defense contractors. And so he got some young ladies to go and sleep with the military-industrial complex types to find out from Pillow Talk why he couldn't get any defense contracts. And that's when he found out that they were planning on doing what's going on right now with, war crimes. I got to be careful what I say here on FlowTube, but so the stuff that's going on, forced medical experiments, war crimes, all sorts of stuff, the stuff that you see nowadays. Okay, and so that's all stuff they were planning on doing way back then. And so Howard Hughes had actually written a set of manuals on how to defeat the whole thing, had it published, and Kennedy was actually implementing that stuff. And they killed Kennedy, they killed his brother, they killed a bunch of other people. And so that's why Howard Hughes was hiding out. He figured he was next probably because they knew he'd published this stuff. And so anyways, and then the helicopter crash, 1984. I think that Trump actually knows exactly who he's messing with, and because I think they tried to kill him too. I think, my opinion, all these billionaires, when they get to be billionaires, they get approached by the New World Order crowd, and they get told you're going to go along with our program or you're going to turn up dead. Remember, Bill Gates went to see Warren Buffett, and all of a sudden Warren Buffett donated $5 billion to the Gates Foundation. Remember that?
Yeah.
And so, but now they've had a falling out. Warren Buffett doesn't want to talk to Bill Gates, and they've had a falling out. So it sounds like Warren Buffett's probably not that bad a guy. But at any rate, I think that happens all the time. And I think Donald Trump was approached. This is my opinion. And I think that he got told that he was going to go along with their program, and he thumbed his nose at him, and they tried to kill him. And the reason I know is because somebody tried to kill him, or I believe they did. It's because there was a helicopter crash in 1984. And I happen to know a little bit about helicopters because I started out working on helicopters as a mechanic in 1976. And so this helicopter crash, what happened is Trump canceled out at the last minute, but 3 of his executives were on board the flight, and it crashed, and it crashed for a very unusual reason, because it crashed because the blades came off. And I've never ever heard of a helicopter crashing because the blades come off.
No.
They'll crash for a lot of reasons. There's no doubt that there's helicopter crashes, and they crash for a lot of reasons, but I've never ever heard of them crashing because the blades come off. And that's what happened anyways. So
Did all his people get killed too, all his executives?
yeah, they did, yeah. He lost everybody on board. When a helicopter like that crashes, nobody survives. Okay? I mean, helicopters are not made to crash. And usually what happens is they get a tail rotor drive shaft bearing that seizes up, and the tail rotor quits working, and then the helicopter, because of the torque, okay, the main rotor creates torque, and the tail rotor is there to counteract the torque, and so the helicopter will start spinning. And what the pilots are trained to do is to go into auto rotation, because they can actually land the helicopter at our location perfectly safe. But even then, it's risky because at some point they got a full pitch when they get close to the ground, and that's going to induce torque into the airframe and cause spinning, and so it's not going to go out too well. I've seen helicopter crashes, and they don't do too well. They're not made to crash. And I saw a helicopter that just rolled over one time, and they thought the pilot might have dozed off or something because it just rolled over. But the transmission was sitting in the back seat. I mean, it was the pilot was okay, but if anybody was in the back seat, they wouldn't have been too good. There was nobody there, fortunately. But so they're not made to crash, and they don't do too well in crashes. Any airplane is not made to crash, and so they don't do too well. Anyways, and then David Wilcock, I told you about him too. In reality, they're not after me, they're after you. I'm just in the way. So, anyways, oh, come on. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. Think about it. So what happened is, in 1861, the southern states walked out of Congress, and Congress ceased to have a quorum, and Lincoln ordered them back under executive authority, and they've been operating under executive authority ever since. And in 1871, they created a corporation called the United States, which is a government for the District of Columbia. That's the other one they're talking about right here, okay? It's the government for the District of Columbia. And that's how they're operating today. Now that thing's bankrupt and got seized by its creditors. So, and all those people are dead now, so they can't reconstitute our government. All those people are dead. And so that's why the military is going to have to step in and reconstitute our government. That's the only way it can happen at this point. And so, and I think that they all have an oath. The interesting thing about the military is the U.S. Army and the U.S. Navy were both created before the Constitution was written. And so, which is, matter of fact, I think they were created even before the Declaration of Independence. I mean, that's what fought the war, right? Along with the militias. So, history, those two classes I hated in high school the most. One was history and the other one was English. And that's all I deal with now. Anyways, a passport. And I'm putting this in here because at that last event I was in Albuquerque, I was telling people about this and they just did not get it. And a passport is a written document given to a person or persons by a commander of belligerent forces authorizing him or them to travel unmolested within the district occupied by his troops. Passports are issued by the State Department or similar office in other countries to diplomatic agents, and others entering and traveling in foreign countries which are the same general character as those issued during war. And the latter should, when practical, have the photograph of the bearer attached. So, again, a passport. And there was a friend of mine, Nelson. Remember Nelson was here? He told me that he saw a YouTube video where this guy had rolled his window down that far and was talking to the cop through the crack and wouldn't give him anything. And the cop finally said, "Do you have a passport?" And the guy said, "No, I do not." And the cop broke his window and drug him out of the car. I'll bet you if he would have had a passport, the outcome would have been completely different. Yes.
So are you gonna talk about the guy that was in Plano that won his case, he made his own passport, and they ruled on it that they let him go because Congress has not made a law stating that you cannot make your own passport?
I haven't even heard of that.
Yeah, I'll try to find the name on it, but he was from Canada, and he put that he was from the Kingdom of Heaven, an Israelite, and he made his own passport, put his name and everything on there, and they hauled him to jail. We went in front of the judge said, he pulled up the rules on a passport here in this country, and there's nothing in there that says you can't make your own passport. And the judge says until Congress rules on that, he's free to go.
Yeah, right on. I'd be interested in knowing about that for sure.
Yeah.
Yes, Jason.
Also, I know someone personally that had one of these so-called 5-star passports, 4-star, whatever, and basically it's not admitting that you're an American citizen and you can identify yourself with it. But he had, lost it or something, and then when he got his next passport in the application process, he used his California driver's license.
Bad news.
All right. So there's a security attached to that. Okay. And so they have jurisdiction. So once the cops had him in the back of the cop car, he heard the California driver's license number being read out. Right. So he used the de facto ID to get his quote national passport, and they tied that ID into it, and therefore they were able to take him to jail.
Right.
Otherwise, it would have said, "Do not detain, do not question." All right.
Right.
That's what these national, state national passports or whatever say.
I can tell you that the Republic of Texas is working on passports, and we'll see. We're hoping to have some passports available for people, so we'll see. This is 18 U.S.C. 1545. It's called safe conduct violation. Whoever violates any safe conduct or passport duly obtained and issued under authority of the United States shall be fined under this title or in prison not more than 10 years or both. So having a U.S. passport would be really useful, that's for sure. I used to, that's all I had. And it's expired, and I'm waiting 10 years after it was issued, and then I'm going to reapply. I'll probably reapply next year, because 2014 is when I had my last passport. But so I'm waiting. Anyways, don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. And on Steemit, don't forget to vote and make your comments. That's the front page of my channel. The subscribe button's already been clicked because otherwise it'll be red. The bell needs to be clicked if you want to be notified of uploads. I just want to go to my YouTube channel here real quick and see what's happening there. Oh, looks like lots of people there. And see if there's any questions. So there's people there putting in comments at least. So they're talking commerce there, but so I don't necessarily go along with the commerce. But anyways, if they're dragging me in there, I do. But, I try and stay away from there. And if they're dragging me in there, I just put without prejudice. Well, that's the end of it. Okay, so now what we're going to do is we're going to go to I've got some Word files I want to go through next, which is the this is the one. This is the Demurrer. Well, that might not be showing there.
So it's interesting, Mer and Mar is the ocean. So I wonder if Mer is actually another admiralty term. Demurrer of.
Well, it's civil law. It's civil law, so you never know.
Is that
French word.
Are you going to? Because I know Demurrer is used with DC Prius.
With what?
DC Prius, when you file DC, you do a demurrer and then a bill of articulates or bill of inquiries.
I don't know anything about that.
So DC Prius means to do before, so it has to be in before it goes to like has to be at the beginning. And so DC Prius is where you're basically claiming that they're contract courts, and under DC Prius only common law and admiralty law exist. And so you ask the judge what jurisdiction, but you put in inquiries where you're allowed to ask 7 questions up to 30 questions, where the prosecutor cannot use presumption of law. They have to prove you have a contract, and they have to prove every element of your questions, like do I have any rights, or can you prove that I'm a U.S. citizen? Can you prove that I'm an alien?
Well, it sounds similar. It sounds similar. I haven't heard of that particular. There's a lot of people on YouTube that have their, I call them unproven theories, and that one might not be so unproven. But there's a lot of people that.
There's a 600-page PDF on it.
Yeah, we tried that before, DC.
Okay, so this is the one about the Demurrer. This is actually one that I got a hold of that was a PDF file, and I've sanitized it. And this is for Idaho. But and we'll go through, what they say, because this has got some really good stuff in it. So the first point is about jurisdiction. John Smith denies this court has jurisdiction over his person. John Smith denies being a citizen of the United States / citizen of the federal government via the 14th Amendment, being an alien from another country, being anything other than a citizen of the state in which he is domiciled, which is Idaho. John Smith further reserves all rights secured to him by the Idaho Constitution, which include both enumerated and unenumerated rights. John Smith denies that any power exercised by government can arise from any plan, any place, except from powers delegated to it via the Constitution. Let's make this bigger. There, that's better. John Smith denies that this court can be empowered by the Idaho Constitution or the U.S. Constitution to acquire jurisdiction over me, and I'd probably change to the alleged defendant. And this is a couple cases on pro se pleadings are to be considered without regard to technicality. Pro se litigants' pleadings are not to be held to the same high standards of perfection as lawyers. And this is another case. Additionally, pro se litigants are to be given a reasonable opportunity to remedy the defects in the objections are taken to be true, be denied, or it must be overcome by proof it is false.
That's real important.
That is like, absolutely.
Right, and also, Glenn, they don't use any law, it's all codes, rules, regulations.
Yes, we know. Overview of this Demurrer.
Glenn, here's an example. I'll let them example. It says, if your mother asks you to clean your room and you refuse, you demur. And if your friend invites you to the Death Metal Forever concert, but you hesitate, you demur. Whether you object politely, disagree, or hesitate, you demur.
Yeah, I'm not getting that at all. And let's continue on with this. I don't want to get distracted by stuff that's immaterial. The Idaho statutes taken as a whole are void for vagueness when it comes to those people, like the alleged defendant, who are only citizens of their state. The Idaho statutes are not the true laws of Idaho as authorized by the Idaho Constitution to be imposed on those people that are only citizens of their state. Point 3, the charge defendant released. John Smith alleges that any other action will constitute a violation of the rules of due process applicable to the alleged defendant, and it will constitute a violation of your oath. Therefore, if the court has jurisdiction of the parties and subject matter, its actions are not void, no matter how erroneous they may be. On the other hand, judicial action without jurisdiction is void, where the court is without jurisdiction and has no authority to do anything other than to dismiss the case. Judicial action without jurisdiction is void. John Smith, Idaho statutes void for vagueness. John Smith alleges that laws are overbreadth or void for vagueness if they impinge on or chill any constitutionally protected conduct, substantial or otherwise. John Smith alleges that this court is a court that enforces all laws on all people all the time, even though this court is deemed to know that not all people are subject to the jurisdiction of this court or all the laws codified in the Idaho statutes. In fact, there is reason to question the authority of even a judicial branch court to enforce violations of the state statutes on people such as the alleged defendant, because the Idaho statutes are not the actual laws of Idaho. The alleged defendant further alleges that due to the ambiguous format in which Idaho statutes are written, they are void for vagueness. So vague, in fact, that they cannot be deemed to be public writings, as such writings are required to be written in such simple language the average person can easily read and understand them. Yeah, so are they telling you that you're involved in a quasi-contract in these kangaroo courts downtown here? The Idaho statutes do not in clear and easy to understand terms citizens that have policy matters to policemen, judges, and juries for resolution on an ad hoc and subjective basis, with the attendant dangers of arbitrary and discriminatory application. Third, but related, were a vague statute to but distinct from the vagueness doctrine of overbreadth. A law is overbroad if it prohibits not only acts the legislature may forbid, but also constitutionally protect. Considering there are two completely independent classes of citizens in the several states addressed further down, when the Idaho statutes are taken as a whole, it is impossible to discern which statutes apply to whom, thus causing those people that are only citizens of their state to refrain from conduct the Idaho Constitution secures as a protected right for them to engage in. Well said. Alleged defendant alleges that the Idaho statutes are both vague for voidness and overbreadth when they are imposed upon those people like the alleged defendant, which are only citizens of their state, because in plain language, they do not give sufficient notice to state-only citizens like the alleged defendant, and the police or judges what conduct is criminalized and what is not, thus causing individuals to defer from engaging in conduct that is constitutionally protected and subjecting state-only citizens to unpleasant forced police interactions and prosecution for constitutionally protected conduct. Hell yeah. John Smith alleges that the Idaho statutes, when imposed on those people that are only citizens of their state, such as the alleged defendant, operate to criminalize constitutionally protected conduct. John Smith further denies that said statutes can be used in a charging instrument for people like the alleged defendant who are only citizens of their state. There are codes within the Idaho statutes, A, whose laws that the state legislature is authorized by the state constitution to make and impose upon people like the alleged defendant that are only citizens of a state, and which enforcement can be accomplished in a judicial branch court, and B, there are those codes codified within that only apply to citizens of the United States and foreign aliens in the state that are administrative in nature. The majority of the statutes comprise laws that only apply to citizens of the United States and foreign aliens in Idaho, and which can be enforced in a legislatively created municipal court. John Smith denies that the Idaho statutes clearly differentiate between those codified laws that apply only to citizens of the United States, foreign aliens, and people like the alleged defendant, who are only citizens of Idaho. John Smith further alleges that the Idaho statutes are void for vagueness when it comes to the alleged defendant. This court alleges all statutes and recognizes none of the limitations imposed on judicial branch courts when enforcing laws upon state-only citizens, such as the alleged defendant. This fact alone is enough to prove that this municipal court and must see all before it. This is a municipal court. Defendant, your court only recognizes the due process rights according to citizens of the federal government. It does not recognize the due process rights of someone like the alleged defendant who is only a citizen of the state. For instance, your court does not recognize the right to a jury trial, much less a trial by jury, as mandated by the Idaho Constitution for someone like the alleged defendant. Your court is deemed to know that every citizen is a federal citizen, and therefore you lack jurisdiction over most of the people that come into your court, yet the question of jurisdiction is never raised. Your court, the plaintiff, and its prosecuting attorney keep this lack of authority completely secret, and people not subject to this court's authority are tried and punished on a regular basis. This speaks loudly about the inherent integrity of your court system. You're a bunch of thieves and pirates. There was complete integrity on the part of all the judges in your court system. The first three sentences would be all I would need to state in order to cause the judge to immediately confer with the DA to determine if any denials could be overcome with facts to the contrary, and if not, the judge would immediately dismiss the case for lack of jurisdiction, as it would be evident to them that they have no authority to move to examining the facts, much less authorize further incarceration of my body. I don't expect that to happen, so further material relevant to the fact that this court lacks jurisdiction over me is provided. Defendant denies. Let's change that. Alleged defendant. Alleged defendant denies that plaintiff stated a claim upon which relief can be granted. If the record does not show upon its face the facts necessary to give the court jurisdiction, they will presume not to have existed. Without a formal and sufficient indictment or information, the court does not acquire subject matter jurisdiction, and thus an accused may not be punished for a crime. John Smith alleges that where a charging instrument does not clearly show facts necessary to give the court jurisdiction over the person, the court cannot proceed to examine the facts and must dismiss. Since there are people in Idaho over which this court has jurisdiction, and there are people like the alleged defendant that it does not, for an indictment or information to be sufficient, the instrument must clearly state the facts proving this court can assume jurisdiction over the person. This statutory provision merely codifies the well-established principle that the courts acquire authority over to adjudicate a matter when they have both subject matter and in personam jurisdiction, establishing jurisdiction on the charging instrument. At this point, we must address what it takes to show facts necessary to give the court jurisdiction and create a sufficient indictment or information. Under our constitutional system, as it has existed since the 14th Amendment was declared and adopted on Thursday, July 9, 1868, two independent and distinct classes of citizens have existed in the several states. This is important information because each class of citizens are under a completely different system of law, and the rights constitutionally secured to them are very different. The original class of citizens being only citizens of their respective states, made up of the white citizens thereof, are required to be under constitutional republican form of government, wherein the several states of the United States only have those powers over them that are clearly delegated to those government bodies by the Constitution by which they were created. The U.S. Supreme Court, hereinafter U.S. Supreme Court, has stated that the powers that the government bodies can exercise are absolutely limited to clearly enumerated powers as those clearly implied and those clearly implied as necessary to carry out the clearly enumerated powers. Before the adoption of the 14th Amendment, the conduct of the citizens of the states, being only white people, were only limited in scope by the regulatory powers clearly delegated to the state via the relevant constitution. No power to regulate their conduct that exceeded that authority could be exercised. The courts have clearly stated the 14th Amendment had no impact on the original citizens of the states. There are many citations on this available. This is true for two reasons. One, the constitutionally secured rights of white citizens of the several states, which are far superior in number to the rights secured to the new class of citizens, were already secured by their state constitution. As such, the original citizens of the states would have gained nothing from this new amendment, even if it had been able to attach to them. Constitutionally, Congress was without power to reach out to the states and make those people citizens of the United States. That's point two. To impose this new federal citizenship created by the 14th Amendment upon the existing citizens of the several states that would have stripped them of the vast majority of the rights secured to them by their states' constitutions. The U.S. Supreme Court has clearly made it clear that once rights attach, they cannot be diminished by any means. Due to this foundational constitutional principle, the original citizens of the states and their posterity retained all the rights their ancestors secured to themselves, for themselves and their posterity, and those like them that had later immigrated to the several states. The fact that the municipal/statutory trial courts are acting on a policy to ignore this fact does not change the constitutions and make their actions legal. Such actions are simply unconstitutional acts committed under color of law and authority. Citizens via the 14th Amendment. The federal government, including the U.S. Supreme Court, have clearly stated citizens via the 14th Amendment are first and foremost citizens of the federal government. Their few rights arise only on the federal level. This is very important because the United States is under a completely different system of law than the several states. It is a system of law, as can be seen in Article 4, Section 3, Clause 2, grants the United States almost unlimited regulatory power over them. This applies even if they're a resident in one of the several states. Those courts have made it very clear that unlike the white citizens of the several states, those rights arise from the state constitution of their domicile, that this new class of citizen derives no rights from the constitution of the state in which they reside. That means that even in the states, all the state has to do is avoid depriving them of a limited form of due process before punishment and avoid depriving them of certain other rights that Congress and the U.S. Supreme Court have declared to apply to them. Under these constitutions, as per Article 4, Section 3, Clause 2, the state and local governments are free to impose any law or rule upon them they please, even if they are municipal corporations, so long as the law or rule can be proven to be needful and not merely oppressive upon challenge. In the simplest terms, the limitations imposed on the several states in the United States via their constitutions over the white citizens of the several states are not binding upon the several states in the United States when making and imposing laws, rules upon citizens via the 14th Amendment and foreign within the several states. In fact, it has been held that the long arm, I just want to highlight this. Because I want to go back later and do something. In fact, it has been held that the long arm of Congress follows its citizens even into foreign countries, and a United States citizen can be punished upon their return for conduct that is legal in the foreign country if it is deemed illegal by the United States or the Union state of their residence. The constitutions of the several states only recognize the common law as being able to impose upon their true citizens, and those constitutions only authorize the prosecution of a white citizen of a state and take place in the judicial branch court under the rules of the common law. There shall be a public prosecutor whose goal is to try and punish those that clearly appear guilty of crimes recognized by the state constitution. In all prosecutions of criminal offenses, the accused shall have, unless they waive it, a trial by jury. Municipal law is the law of the United States. Since the 14th Amendment citizenship is the citizenship of the United States, that system of law follows them wherever they go in the several states. All trials in the United States are in legislative branch courts, municipal courts authorized by Congress, and there's no right to a trial, no right to any jury. There is only a right to a trial by a fact finder that can prove they have no bias in favor of the prosecution. In fact, it has been decided that these judges must have a bias toward ensuring as much as possible that the federal citizen has the best chance of justice as can be provided, even if the judge has to go out of their way to assist them in understanding the few rights they have in their defense. As can be seen, the system of law and even the courts and the forms of due process that apply to these different classes of citizens are very different. As per the constitutions in the several states, there must be a judicial branch court to hear all cases brought by a public prosecutor against those people that are only citizens of a state. A judicial branch court, being a court of superior jurisdiction, has the authority to act both judicially and administratively. As such, they can preside over both constitutional and municipal law cases. Legislative branch courts and legislatively authorized municipal or administrative courts within the several states are unable to be endowed with the authority to preside over a case where a state's only citizen, such as myself, is an accused, because no such power is delegated to the state or federal government when in the several states to endow anything but a judicial branch court with judicial style powers over state-only citizens. Charging instrument. Due to this dual set of citizens and system of laws and the courts that exist in the several states, for a charging instrument to provide upon its face the facts necessary to give court jurisdiction and therefore qualify as a sufficient indictment or information, the prosecuting attorney must state the system of law the case arises under and the authority for the decision and the nature of the court in which the charging instrument is filed, and if the charging instrument is filed in a municipal court, in order for the court to assume jurisdiction and to apprise the defendant of the system of law the court is moving under and from where it gets its authority. Yeah, no joke. And they're not doing any of that stuff. If the prosecuting attorney fails to disclose this information, the accused, if they are only a citizen of their state, such as myself, has no way of knowing if they're being tried under the system of law that applies to them, and in a court that actually is capable of assuming jurisdiction over them, or if they ought to demur on jurisdictional grounds. If the charging instrument is filed in a judicial branch court that decides both common law and municipal cases, the same requirement to establish the case to move forward under municipal law must still be present. Absent proof the case can move under municipal law, the court must assume jurisdiction and move under the rules of the common law. The constitutions were ratified to create a government to serve those people that are only citizens of their states. Among the powers not delegated to the several states or the United States is the power to take advantage of their ignorance or to use deception or coercion or deprive them of their rights. Due to this, the district attorney has a constitutional duty to be totally forthcoming when it comes to all information that might lead to the prosecution of a state-only citizen. John Smith denies that any indictment or information that does not meet this criteria is a valid instrument. John Smith denies that the charging instrument before this court, or in this case, meets the high standards of qualifying as a valid charging instrument. John Smith denies, therefore, that he can constitutionally be compelled to provide any answer to the charging instrument other than a demurrer on the case that the charging instrument is constitutionally defective. John Smith denies that this court has any option other than dismiss this case, as John Smith denies that this court or any court can assume jurisdiction based on a defective charging instrument. John Smith alleges that the prosecuting attorney and courts have a policy of fraud in which the prosecuting attorneys file all cases in a non-judicial branch court with full disclosure to the accused, thereby engaging in a policy of prosecuting a state-only citizen in a court without jurisdiction for conduct secured as a right to engage in by their state constitutions, whereupon the court, which is without jurisdiction, proceeds to convict and impose punishment. John Smith alleges that this is all based on the carefully orchestrated and programmed ignorance of the state citizen, often backed with intimidation with the intent to deprive them, including himself, of their constitutionally secured rights. John Smith alleges that this is one of those situations where his case has been filed under a system of law to which he is not subject, or in a court that cannot assume jurisdiction over him. Alleges. Yeah, this sentence needs some work. That this action against him has been intentional or the result of negligence. John Smith is taking the above alleged fraud into consideration and does make the following denials. John Smith denies that the current charging instrument provides enough information for this court to determine if it has the authority to assume jurisdiction. John Smith denies that any court can acquire jurisdiction over him based upon such an incomplete charging instrument. John Smith denies that the current charging instrument provides enough information for me to determine if it is brought under a system of law that does not apply to me. John Smith denies that the current charging instrument provides enough information for me to know if this court has authority to assume jurisdiction over this case. John Smith denies that the current charging instrument provides enough jurisdiction information to escape being declared void for vagueness. John Smith denies that the court in which this case is filed can assume jurisdiction over me based on the present charging instrument. John Smith denies that he can be held to answer for any alleged illegal conduct in anything but a judicial branch court. John Smith denies that this is a judicial branch court, and further denies, therefore, that it has jurisdiction over him. John Smith denies that without a statement clearly stating the jurisdiction being imposed upon him to include the system of law the plaintiff is moving under, he's been afforded notice to be able to determine if his conduct is actually subject to investigation by a court. John Smith therefore denies that he can be prosecuted without knowing if he is a person subject to the system of law being enforced and therefore subject to this court, or if his alleged conduct can constitutionally be criminalized. John Smith denies that plaintiff's representative, the DA, constitutionally qualifies as a public prosecutor. John Smith denies that plaintiff's representative is anything more than a corporate attorney for the plaintiff. John Smith denies that he can be prosecuted by anyone except a public prosecutor, moving under the rules of the common law in a judicial branch court and acting in the name of the state that, like himself, are only citizens of Idaho. John Smith denies that the charging instrument cites proof plaintiff has standing. John Smith denies that the charging instrument provide any evidence any constitution grants plaintiff the authority to be the plaintiff in a criminal action against him. John Smith denies that the Idaho Constitution grants the plaintiff the authority to be plaintiff in a criminal action against me. John Smith denies that any constitution grants the state of Idaho the authority to grant this court any authority over him. John Smith denies that this court has any authority to evade their duty to immediately dismiss this case against me and order my immediate release. So, and that's it. He nails it pretty good, eh? What you say?
Hey, Glenn.
Yeah.
So there was this guy. It's in Black's law. The word instead of you might want to look at instead of denies, using the word recognize. Does not recognize. This guy went to court. They called his name. He said that I do not answer the name and I do not recognize you. The judge, I do not recognize the prosecutor, I do not recognize. So the word recognize is in Black's law. And what he was saying is that he doesn't recognize the King's Court.
You know, there's a lot of people that have I call them unproven theories, and that's a case of I've heard that before, and you know, they got the guns, and when they drag you in there, you know, I don't you know, you might be able to get away with that. It depends on the issue, but if they drag you into their court and they have a bond on you, then they'll just revoke the bond, and you'll go to jail, and you won't even be able to get a pen and paper to write on.
No, you're missing the point. What I'm saying is, instead of using the word deny, would you use the word do not recognize since that's in Black's law?
Well, you know, it's really a civil matter, okay? And you know, I don't know. I have to think about it. You know, that's something I have to think about. Something like this sounds pretty good, and I don't like to make a lot of changes to somebody's document. But it's something to think about. I don't know. Do not recognize.
Does this actually work for this guy?
Huh? I don't know. I got it. It's really, it brings up all the issues that we all have. And so, you know, I have no idea. I got it. It's Idaho. It's a case number. Obviously, he was in their jail, it sounds like, although I don't know how he put that together, being in their jail, because you know, they don't even give you pen and paper in their jail, any of these jails. But the thing about you know, that I've learned is when they have you in their jail, you get focused, you know, and all it does is get me pissed off, and so I'm pissed, and I have an agenda, and I want to break it off in their ass in a way that they can't possibly imagine, and you know, so that's where I'm coming from. What?
That was written for a U.S. State Court. In my case, would I change that to a state district court?
Of course. Anyways, so this next one is the discovery, the Demurrer, the discovery. Okay, and this one is yeah, I know where track changes is, thanks. Anyway, so there's right now about 50 viewers. So let's go on to the discovery, because this is actually pretty short and sweet. It's 4 pages. Comes now, John Smith, a natural person, in above styled action. John Smith denies this court has jurisdiction over his person. John Smith denies being a citizen of the United States, being a citizen of the federal government via the 14th Amendment, being an alien from another country, being anything other than a citizen of the state in which he's domiciled, which is Idaho. John Smith further reserves all rights secured to him by the Idaho Constitution, which includes both enumerated and unenumerated rights. Regarding pro se filings, referred to Demurrer. Now, there's some stuff that I've been thinking about adding into this. So I'm still tweaking this and adjusting it, but there's some stuff I've been thinking about, like the fact that, for example, in my case, I can show that Will Livingston is my 4th great uncle, and he ratified the Constitution for New Jersey, which means that I am posterity as found in the preamble, and I have red blood, and there's maxims of law that come into play. Anyways, I'm thinking about adding that for my case, although I don't have any cases going on. They don't want to talk to me. But the one thing I learned a long time ago is when they get down, you kick them when they're down. Okay, you make sure that they're not getting back up, and so you kick them when they're down. And so anyway, so that's one of the reasons I do these videos. So I'll kick them in the teeth while they're down. Anyways, John Smith denies that the plaintiff can prove any of the requested material is not relevant to the determination of my guilt or innocence, or the ability of this court to impose punishment. If any of the requested material exposes the fact that for any reason the plaintiff lacks standing, or the court or any reason lacks jurisdiction, my right to it as exculpatory material is absolute. In fact, it is the duty of the plaintiff in a criminal prosecution to voluntarily turn over all exculpatory material. John Smith denies that any material that has the potential to expose that the prosecuting attorney has no constitutional authority to move against him can be determined irrelevant. John Smith denies that any material that has the potential to expose that he is not subject to the system of law this court enforces can be deemed irrelevant. The plaintiff is listed as state of Idaho. What is the plaintiff? Is the plaintiff a municipal corporation? I request a charter for this municipal corporation to determine the limits of its authority. Who are the stockholders of the plaintiff? Please provide the section in the Idaho Constitution that authorizes plaintiff authority to be plaintiff in a criminal style action against me. If it is conceded that plaintiff is a corporation, please provide the section in the Idaho Constitution which authorizes any corporation to be granted any authority to be plaintiff in a criminal style action against me. Please provide the section in the Idaho Constitution which authorizes the DA, corporate legal attorney for the plaintiff, to act in the same capacity as a public prosecutor in a criminal action against me. This court, please provide all details about this court, including papers of incorporation and charter. If it is conceded that this court is a corporate entity, please provide the section in the Idaho Constitution where the municipal corporation court can accept jurisdiction over me. If you deny that this court is a municipal corporation, please provide proof that this court is one the legislature established as a judicial branch court in harmony with the Idaho Constitution, Article 5, Section 2. If it is claimed to be a constitutionally authorized judicial branch court, please provide the section of the Idaho Constitution where this court is authorized to treat me as if I'm a citizen of the federal government or a foreign alien. If it is claimed to be a constitutionally authorized judicial branch court, please provide the section of the Idaho Constitution where this court can deny me a common law trial by jury. If it is admitted that this is not a judicial branch court, please provide the section of the Idaho Constitution that authorizes a legislative court or a non-constitutional statutory court or any municipal court to exercise judicial style powers over me. Please provide the exact system of law this court is moving under, enforcing. This includes the actual name of the system of law. For instance, in the United States, the system of law is called municipal law. Please provide me with the section of the relevant constitution that makes me subject to the system of law, which is not recognized by the Idaho Constitution that this court is moving under and enforcing. This court enforces a system of law that is not authorized to be imposed on me by the Idaho Constitution. This appears to be some secret system of law because I cannot find any information on it. Please provide full disclosure on the secret system of law enforced in this court. Please provide full disclosure on the presumed authority this court claims to be operating under and impose this secret system of law upon him. Please provide full disclosure on where I can find the rules for this system of law, because he has not been able to locate any detailed published information on the system of law and its rules. I state that denials of due process is slavery. I state that without knowing the nature of the system of law and the rules it goes by, I am denied due process because without that knowledge, I cannot mount a relevant defense. I state that denial of the sought discovery, including the proof this court has the established authority to proceed in this case, denies me the ability to mount a relevant defense and therefore denies me due process. I state that a denial of due process to include the right to mount a relevant defense constitutes a declaration of slavery upon me, because I claim that only a slave can be denied due process, which includes the right to at least try to mount a relevant defense. John Smith denies that any of this material can be denied me without violating my constitutionally secured due process rights, because all evidence is relevant to the ability of the government upon me. And that's it. That's 4 pages. That's pretty short and sweet. Anyways, he kind of nails it there. Some of it, there's stuff I would probably change there, but if I did anything, it'd just be add some stuff in there and make it more juicy. You know what I mean? But anyways.
Yeah, it's pretty good. It's basically just saying he's a state citizen. This is all corporate. You're not of the people and by the people, and you have no laws that apply to me.
Yeah, and again, I mean, the 6th Amendment, the 7th Amendment, you're entitled to the nature and cause of what you're dealing with. And so you're forcing them to provide it in great detail. You know what I mean?
If you can't provide the law, you basically just shut up and remain silent until they do something.
He's saying there's a conspiracy to conceal the actual goings on here.
Yeah.
Deliberately, keep
Yeah.
it in the dark, and deliberately applying a system of law that they know does not apply to him.
Right.
Or they reasonably should have known.
Absolutely. Well, no, they're a bunch of pirates.
At some point, Glenn, they don't respond to you, say, I have no further business here. And
Well, no. This is going to get filed into the case, and if you read what a demurrer is, the case is held up until they overcome the demurrer.
So you did all by paper and
Right.
court.
Right, and they have to overcome this demurrer, and that's where they're forced. They can't do anything until they overcome the demurrer. You see what I'm saying?
Yeah.
That's what makes it so powerful. And this is a challenge to jurisdiction, and it's only 3 pages. So comes now John Smith, a natural person in the above styled action. Alleged defendant denies that this court has jurisdiction over his person. Alleged defendant denies being a citizen of the United States, citizen of the federal government via the 14th Amendment. I mean, what they're doing is they're bringing, it's a Commerce Clause, okay? And so Article 1, Section 8, Clause 3. And so I'd have to think about, the thing is that you don't want to tell them too much. You make them have to prove it. And so you don't give them anything. You see what I'm saying? And that's a lot of what his strategy is too, in my opinion. He's not giving them anything. He's making them prove it. And what they have to do is they tell them, well, we're under the Commerce Clause, and this is a contract. And where's the contract? You see what I'm saying? They're never going to prove it. They're going to drop it. It's probably what's going to happen. Anyways, the alleged defendant denies being a citizen of the United States, citizen of the federal government via the 14th Amendment, being an alien from another country, being anything other than a citizen of a state in which he's domiciled, which is Idaho. The alleged defendant reserves all rights secured to him by the Idaho Constitution, which includes both enumerated and unenumerated rights. The alleged defendant makes the statements below. All issues are covered in detail in the Demurrer, and I'm not sure what that is.
And Glenn, one time I heard somebody say, I'm not a U.S. citizen, and the administrator said, do you want us to contact your consulate?
Sure.
Yeah.
Let them define how, yeah, of course.
So they're assuming you're a U.S. citizen, but either that or you're an alien. Okay, so you got to specify that too. And refer the reader to the Demurrer for details instead of duplicating many pages of paperwork. Rights of pro se regarding paperwork, see Demurrer. Rather than trying to get complicated in sentence structure to create elaborate and hard to understand denials for the plaintiffs to try and overcome, in order to simplify things as much as possible, I make the following statements that deny the plaintiff can prove me wrong. And deny the plaintiff can prove me wrong. Idaho statutes taken as a toll or void for vagueness when it comes to me. Idaho statutes are not a true system of laws of Idaho as authorized by the Idaho Constitution to be imposed on me. Therefore, Idaho government employees, what they're for. The charging instrument, but that's, so he's not telling them that, okay? He wants them to tell him that. Anyways, the charging instrument is defective. The plaintiff lacks standing. The district attorney lacks standing. The Idaho statutes are overbreadth and void for vagueness when imposed on me. I am not a person subject to the system of law this court enforces. I'm only subject to the common law embodied in the Idaho Constitution. This court is not a court established by the legislature in harmony of Article 5, Section 2 of the Idaho Constitution. The government of Idaho is constitutionally forbidden to prosecute me in any court not established by the legislative authority of with Article 5, Section 2 of the Idaho Constitution. This court is constitutionally barred from acquiring jurisdiction over me. He must allege in his pleading the facts essential to show jurisdiction. If he fails to make necessary allegations, he has no standing. If his allegations to jurisdictional facts are challenged by his adversary in any appropriate manner, he must support them by competent proof. Jurisdiction over a defendant requires both personal and subject matter jurisdiction. This statutory provision merely codifies the well-established principle that the courts acquire authority to adjudicate a matter when they have both subject and in personam jurisdiction. Therefore, if the court has jurisdiction of the parties and subject matter, its actions are not void, no matter how erroneous they may be. On the other hand, judicial action without jurisdiction is void, where the court is without jurisdiction and has no authority to do anything other than dismiss the case. Under the Federal Rules of Civil Procedure, 60b-4, void judgments entered where the court lacked either subject matter or personam jurisdiction, or that were otherwise entered in violation of due process of law, must be set aside. Mandates the setting aside of judgments if the court lacked personal jurisdiction over the defendant against whom it was entered. I'm not a citizen of the United States, see Federal Rules of Civil Procedure. So the Federal Rules of Civil Procedure do not secure any rights to me. However, it is quoted because it is simply the common law codified, which is the system of law I am under, because that is the law incorporated into the Idaho Constitution. And that's it. I mean, it's pretty short and sweet, and that's one thing that I like is short and sweet. Yes.
So I don't have it with me, but I'll send it to Darren. Would you consider also putting in there Bill Brooks' case where it says that they have no qualified immunity? There's a case that ruled against them having qualified immunity from any prosecution or penalties.
You can put in a lot of stuff like that. The question is how much longer do you want to make it? You know what I mean?
Well, I mean,
it's nice to have it short and sweet. And right now he's trying to get it dropped. Yeah. And if the judge drops it, you know, it depends. I guess it depends.
Well, that's what they operate on, that qualified immunity. That's how they get away with all of it. But
Yeah.
But you could ask the question, you know, do you plan to ignore or overturn Millbrook's case that says that you have no qualified immunity? You could ask them in a way that they would go against the law.
Right.
I mean, it's case law.
Once they've been noticed that they're operating outside of the scope of their authority, they have no qualified immunity.
Well, you know, I think it'll be interesting to see what they do with the Demurrer, because they're supposed to stop everything until they prove what the case is as a matter of law, and it's creating a problem for them for sure. They have to answer it somehow. And again, you can, that would be, once you file that, and they went and ignored it or overrode it, or not ruled against it or something, that'd be great to put in that mandamus, file a petition for writ of mandamus. You know what I mean?
Yeah.
And ask them to prove if they ignored it or something like that. I mean, that would be great for a mandamus.
I'll send it to Darren.
I believe too. Might be a good idea to go ahead and just give them a bunch of work to do too. Give them interrogatories and admissions.
Well, you can certainly expand on that.
Because that one, they'll say, I want to get rid of this guy. It's too much work.
Yeah.
Yeah.
Well, there's a guy that was used to be an attorney that brought East Prius, and he says you don't want to do more than 30. He says if you go over 30, then they really start cracking down. And,
Yeah. Well, with admissions, you get 25.
Yeah, 25.
But you could do production documents, admissions, depositions, and interrogatory. Just send a big old package of stuff for them.
He says, yeah, you do seven questions at a time for interrogatories, but you could send up to 30. If you send in seven, you're only able to do 7 per page for each interrogatory.
Yeah, well, that's why I was thinking about, like, there's a McCullough versus Maryland that said that the government doesn't have authority to do anything to a state national, which is why they have to put you under the Commerce Clause, which is what they're doing. But you don't say that. You make them tell you that. Okay, a contract. It's a contract. Okay, and so where's this contract? You see what I'm saying?
Yeah.
You know, they're not going to want to bring that out. I mean, they're a bunch of thieves and pirates. Don't get me going.
You need to understand too that because of the Commerce Clause, if you can, we want to go in here with something this wide and big sweep. Don't do that. Just come down here and say, okay, under the Commerce Clause, and make them defend it.
Well, and it's the minor estate.
Correct.
I mean, that's why. But I talked about that in my PowerPoint presentation, but it doesn't say anything about that in this because it's a felony. And so I'm not sure that I would bring it up, but you could bring it up.
Because it's a what?
It's color of law. It's a felony. They're engaged in a felony.
Correct. But the color of law is they plain color of law.
Oh, everything they do is color of law.
So when I have any questions like this or anything like this goes against me, I play color of law all the time. Here's my card. It's red. It's red. It's red. I mean, the color of law has no, it has no effect at all.
Yeah, it's not law.
It's not law.
It's a fraud. And when you point it out, then they start getting uncomfortable.
Yeah, but that's and you know that because they start hollering at it.
Right.
They'll start hollering at it. What are you trying to say? I'm not trying to say nothing.
Yeah.
But the color, it's the color of law that they use. And they got these big $800 suits on, and they gives you a pit in your stomach. But
Everything they do is color of law.
correct.
anyways, I think I'm going to end my live stream. I don't have anything else to talk about, but
Let's see if we have enough people for a common law case today. 2, 4, 6, 10, 12, 14.
Question is, what has changed since that upcoming Nobel Peace Prize guy last week, now that you're willing to do a common law?
I don't know what are you talking about?
Well, he gave us some guidelines last
You
week.
did, but where is the recorder and
He says that you need to serve the opposing party. Gary Shreddy had it too right there.
Well, everything is. I mean, anytime you're in court, people don't get that stuff. You have to build a case.
Alright, so
Yeah,
what
well,
is, what has changed now that you're still willing to do this because?
Yeah.
There he goes, he's got it. What has changed now that you're still willing to proceed,
Well,
even
that's
though that
just
we
what-
didn't have everything?
That's what he says. That's what he said. He said we also should do under the international law instead of the Republic of Texas. Whenever we, have hearing, he said it's better to do international. It has
Who?
this is.
Oh,
what
Kevin Annette.
Annette said.
Yeah. Well, I'm willing to see what he's got to say. I'm curious.
You said you
But-
need to help public as well.
You make it publicize it too, invite everybody you can to the meetings to get you better
Yeah, because
protection.
in the last case, they went out on the radio and put it out on a billboard how they won. So how, unless you're willing to have the money to go out there and publicize what you're doing. He's saying that, they're still in the private zone.
Well, that's interesting.
He said
Right.
that's what helped them when they got rid of the Pope. It was public.
Well, and I'm not, that's interesting. I guess I was there when they there was a common law court in over. I don't know if you remember Susie Kamak that had her house was going through foreclosure, and she had a Republic of Texas common law court that was helping her with it, and Kerr County and the Texas DPS and the U.S. Marshals and the FBI raided our Republic of Texas Congress. They stole my laptop. I still haven't got my laptop back.
Right.
So if you want to tell us about that, knock yourself out. I'm a little bit shy now. I'm sorry. I don't know what to tell you.
You'd be wise to invite.
Well, I didn't know.
So
that.
you wanna knock
I'm just
yourself
trying to
out?
figure out
Go
why.
ahead.
No, that's true.
That's just
Figure
what
out
Kevin.
what
Kevin
has
said
changed
that's
now.
what we should do, and I don't mean it's the best
He's
thing
saying
for
if you
us.
don't have the court recorder, which he said that should be somebody that does it as a job.
Well, that'd be good. That'd be good if we had all that stuff, but we don't have enough people hard to get out to be a jury.
There's just
Well,
we're working with limited resources.
There are a
I get
bunch
that.
of thieves and pirates. Don't get me going.
Here.
So,
Anyways,
our good friend up in Missouri has been locked up since January 11th. Had her house stolen, they kicked in the door, all her resources, including her computers, paperwork, anything she had, been cleared out of the house. They stole her cars. She had a land patent on her land. Okay. They've charged her with 4 counts of interfering with a judicial official, all right, and with a $10,000 cash bond. And so right now she's, I don't know what all they filed in this thing, but she wants to rescission all of it and apologize. You know, because she wouldn't even put on they call her woman. When she calls, she goes, woman is calling. Yeah, Blessing is her name. Y'all know Blessing, right? I need to say a prayer for her. Because she wouldn't wear the bracelet, they kept her in solitary confinement. I don't know if she ever put the bracelet on.
Has she, how's she signing stuff? Is she signing stuff? They always give you stuff to sign.
No, none of it. You know, she hasn't signed anything.
Well, no, you gotta sign. What you do is you put without prejudice.
Yeah.
If you don't sign, they just put refused and you sign.
But, you know, they're trying to create these bonds, right? It's
Well-
kind of like, somebody sent me a thing.
I've signed bonds without prejudice. Okay, I've signed plea bargains without prejudice. No problem. I don't even put a signature there. I just put without prejudice.
Right. You know, I realize that this is the original slave system, but, you know, somebody sent me something off the debt clock or something like that, and it says, you know, about the green money going away, the Ponzi scheme. And I replied back, the Ponzi scheme that made this the richest country in the world, okay, our ability to print money, you know? So arguably these bonds, I know it's all, arguably these things have built cities, you know? So you are interfering with their business. You know, you are interfering with their business. They're not allowed to play. And
Well-
I was talking to somebody the other day, supposedly Trump signed something acceptance. That's one of those court cases went away, so they could go in, collect their money out of the trust, or not collect out of the trust. Supposedly they're not